Thanks for joining us here. Steve Baxter from Transition Level Investments, TEN13 here, with a fantastic friend of our firm, Ashley Tiplady from Mills Oakley, who's a partner in the litigation and commercial area. What we've decided to do here, given everything that's going on, is we want to have a good chat about contracts. And this started out as a force majeure conversation because Mills Oakley released a fantastic document last week, the week before, regarding force majeure. Given everything that's occurred over the weekend with the federal government's support and some of the regulatory moves with respect to insolvency and safe harbour and other bits and pieces, we're going to try and have a wide-ranging chat on a bunch of facets around this area. Ashley knows far more about this than me, that's for sure. But we'll stick to the initial intent of this argument. Well, actually, first of all, I might get you to quickly introduce yourself for maybe 30 seconds.
Thanks, Steve. Ashley Tiplady is my name. I'm a partner from Mills in disputes and insolvency. As you can imagine, with all the uncertainty that's going on, we're pretty busy at the moment and trying to give back a little and help guys with some free advice to try and get you through, because we do realise how tough it is with your cash flow and your employees. So thanks, Steve, for the opportunity to have a chat to people.
No worries at all. As I said a few times on a couple of these sessions, there's a bunch of professionals out there who want to help. Don't get it wrong. This is business development for these guys. These guys will, they're out for work, but at the same time, they're introducing this content. They're giving you some basic tools to start thinking about this and who to be able to use. So look around firms such as Mills Oakley. First of all, I always looked at force majeure as being one of those boring pieces of content at the back of a contract I paid absolutely no attention to. If you can walk us through probably briefly what is force majeure, and there's a lot around that with respect to the current COVID-19 outbreak and how that might be pertinent to some of the audience.
Isn't it funny? It is one of those clauses that sits in contracts that people go, oh, why is it there? It's never going to affect me. But here we are, where everyone's running to have a look at what it means. So force majeure is Latin for superior force.
No, I didn't know that. Probably should look it up, shouldn't I?
It's important to know it's only contract based. There is no common law in Australia that deals with force majeure. So what it is it's a supervening event that means performance of a contract is rendered impossible. Now so being contract based, it can provide a couple of things: a potential right of termination, or it can, I'll call it, relaxed performance for the duration of the force majeure event. But what's interesting here and what people are going to look at is it's the individual wording of each contract that's going to give you your rights, whether or not the contract is suspended for that period or whether it does give you a right of termination.
So typical things in force majeure are things such as riots. Is war in there?
Wars, maybe acts of God, that sort of...
Labour disputes, is that as well?
Can be, yep. But it comes down to that clause, Steve, that it's what's there.
Do you often see a pandemic clause inside of force?
I haven't seen one in the last 3 days, and let's say I've read a few. So once again, what's your contract says.
Yeah, so we actually had an instance. We were supposed to take a group of 12 investors to San Francisco in May. We prepaid the hotel rooms. That was clever. But there was a force majeure clause in the contract that said if more than 50% of people can't make it due to legal reasons, and the travel ban was a pretty good legal reason, then we pulled the force majeure and it worked in our favour. So they are useful, and everyone should take a look at that.
I think so, because people got cash flow concerns, so people are going to be looking to enforce contracts. But if you've suddenly got contracts which aren't going to help your business, leave relationships to the side for the moment. Do you try and terminate to keep your cash in bank and stop damages claims?
Now, is it literally something you should trigger, or is it like all things, a contract is the two parties should conduct themselves and you put it in writing so there's no misunderstandings later on? But do you advise, and how do you see, I suppose, force majeure being used by companies in these situations? Is it like, let's renegotiate this, renegotiate parts, or do you use a big stick threat that you can throw this out, that liability?
I think each set of circumstances will be individual, so you've got to figure out how to play it, if I can call that. Only this morning I was giving some advice to restaurants and nightclubs in relation to their leases, and unfortunately their leases didn't have any force majeure clauses, so that was off the table. But if one did have, landlords, they're going to need money too, but they can't be too greedy. So it probably does open the doors for some renegotiation and some, I'll call it, human touch.
Yeah, we might get into leases a bit in the back end of this, because there's probably some stuff to follow, and given what the Prime Minister announced on the weekend with respect to the 6-month holiday on insolvency, that's my definition. You've probably got a more legally relevant definition than that. We might touch on that a bit later. Is there case law that matters when it comes to force majeure?
Yeah, there is. So cases, the bottom line is each clause is an individual clause. So you've got to have a look at whether the definition of the events is inclusive or exclusive. If it's an inclusive definition, obviously you're stuck with those particular words. If it's exclusive, you can try and import more into the circumstances.
Inclusive, exclusive, sorry.
So if a clause sits there and says these are the events, it's a defined term, including.
Right, yeah.
But if there's an opportunity to imply more in there, so it's not necessarily excluding anything, it's the clause has got a wider operation.
And is it used pretty creatively? Have you seen some sort of interesting out of the box? This is an out of the box event, and we've got a wide variety of people who be watching this. So what's the crazy you've seen with respect to force majeure?
It's just starting to happen. I came across it in the 2011 floods when insurers were trying to walk away from insuring people and paying out.
Sure, it's fancy that. You never think that, would you?
Well, I've got to digress. Can you imagine a big insurer saying that a prior insured event was trumped by a subsequent total destructive uninsured event and refused to pay out?
Well, there you go.
Anyway, issue for another day.
Yeah, my word. Well, that's next week's podcast.
But yeah, look, it's going to come. People are going to be using these clauses and having a look at them. As I said, is it going to be termination, or is it just going to suspend performance of the contract whilst we're in our current state and probably beyond? And let's face it, we're probably 3 or 6 months that's going to be like this at least.
Yeah, the calendar year's cooked, isn't it, really?
So yeah, once again, I seem to be repeating myself. You've got to read your contracts and just see what they say and what they provide for.
Is there a gentle way you can raise force majeure with your counterparty, a contract counterparty, or is it just you send a notice, phone call? Obviously the probably less combative the better at first, at the very least anyway.
I do think so. I think you're better off picking up the phone. Let's face it, we've got keyboard warriors in society today, but there's nothing better than picking up the phone and actually having a discussion with people, and sure, maybe you say, look, I've got abilities under force majeure, but I don't want to do that. I understand we as a society have got to help each other, so I'll jump into leases again. Maybe if, give me a 3-month rent-free holiday, but I'll come back and talk to you, or give me half rent or quarter rent for a period of time, or we agree to suspend services but keep the contract running until, have a look at your sporting clubs. We've just seen the last couple of days there's going to be mass stand downs at the NRL and the AFL and the A-League. So there's got to be opportunities for people to pick up the phone and negotiate. So yeah, I do think soft first, and then maybe go and see your lawyer if you need to harden up a bit and throw some concrete around. Yeah, so
we're specifically talking about force majeure in a lot of cases, but there's a lot more in the contract other than that. And now there's also been a lot of regulation and government law and fiat laid over the top of that, travel bans, congregation bans, 4 square metres, 500 people, 100 people. You can't go to Bondi, or the Gold Coast beaches, I imagine, as well. So does any of that government dictate and edicts, do they actually affect and ripple down through contract law?
They do, and look, that's a good segue into talking about some principles about frustration and impossibility in a contract. And frustration is where, because of a supervening event out of the control of one of the parties, the contract's no longer able to be performed.
Now, in my research for this, frustration actually has some case law with respect to SARS back in 2011 or something. I can't remember when, but so is that applicable now? Maybe going to frustration, there's some pandemic specific.
There is, and look, probably the best example at the moment would be your football clubs, where your Brisbane Broncos, your Titans, where they've got membership, and people have contracted to have a season ticket that allows them to attend 10, 12, 14, 16 home games. And because of the shutdown where you can't have more than 100 people or whatever it is in public areas, all the games are being played behind closed doors. So because of an event being the government regulation, you've got a party being the football club who can't deliver the services that it was contracted to offer.
Yep.
So that contract has been frustrated because legally they can't give people their corporate hospitality or give them a bum on a seat at a game. And so frustration opens the door for termination of contracts.
So how wide can that ripple through? So how many times removed can the frustration event be for it to be something you can have a discussion about with the contract. So, for example, that if you meant to deliver service between two parties, but because someone else can't deliver because they're frustrated, is there a concept of inherited frustration?
Well, it leads to probably your ripple effect of a supply chain is probably where you are going. If I've got a widget and I've got a contract to deliver you 10 widgets a week, but my manufacturer in Thailand or China can't give me the widgets, I don't have the ability to perform under the contract.
So you guys are already frustrated, but your supply chain has been frustrated in some respects.
Correct, yeah. And I think we're going to have a lot of that now, where supply chains are going to be frustrated because we can't actually get the goods.
So would that then transfer to force majeure in that case then? They're frustrated. Or could potentially, obviously it has to be included or not excluded, I think.
Well, I think that the difference between a force majeure or a frustration event is, for a force majeure, the contract just can't be made more difficult to perform, more expensive to perform, and less profitable. It's really got to be unable to be performed.
So the other one you said was impossibility, which is...
That sort of dovetails into your frustration because of the contract is impossible to perform, it becomes frustrated.
Yeah.
And the more interesting area perhaps is illegal contracts and whether or not they're enforceable. Illegal contracts. So as a general concept, someone can't enforce an illegal contract.
Right, so if the government says you can't travel, your contractor says you'll supply travel services, then it's...
Yeah, look, it's
so you can't be made to break the law, essentially.
That's right. It's not something that's come across my desk yet, but I'm sure it will, because how can someone enforce a contract that the government says you can't do? Yeah. So how do you have a damages claim for that? So this is a moving feast in a legal sense as well as it is in an economic and social sense.
Yeah, there's no shortage of issues there. Legal contract, supply chain frustration, limit of liability clauses. Another one of those fantastic clauses in a contract we all love going through as entrepreneurs. Probably really quite important at this point in time.
It is.
We understand that.
Now you can contract out of liability to a degree. Let's leave consumer law protections to the side for the moment because that's a whole different kettle of fish. But you can contract and say you're not liable for direct, indirect, consequential loss, economic loss, etc. arising from a breach of contract. And most of the time that'll hold up, leaving penalty law to the side. Yep. So you can contract out of liability. Once again, it comes down to the specific terms in the contract, and there's a hell of a lot of case law about consequential loss and indirect loss. Yep. But just have a look at, what is my maximum exposure? Again, it's probably a bit of a legal nufty thing that you're going to need to get some true advice on.
Well, speaking of legal nufties, when you introduce yourself to me, you said, I'm a legal nufty, so I'm just going to take the time again to say, if you've just tuned in, I'm here with Ashley Tiplady from Oakley out of Brisbane. He's a partner in commercial disputes and litigation, Insolvency, that's the one. Talking about all things contractual, this is like a force majeure cast, for want of a better term. So I just wanted to sort of cover that off again. Once again, that's Mills Oakley, and it's Steve Baxter here from TEN13, Transition Level Investments. So we sort of, I bumped in there halfway through the limitation of liability. That's like I said, it's a lot. I've had a lot of struggles over the years with understanding the relevance of a lot of that. Is it easy to wiggle if you've been the lazy entrepreneur, I suppose, the lazy founder, and said, well, that's never going to happen. Let's not worry about that. Is that sort of stuff? Can that be bundled into frustration, impossibility, illegality, or is that sort of stuck in the contract?
It's probably stuck in the contract. Once again, your limitation of liability. Probably an adjunct example is your consumer law protections for defective goods, where you've either got to give the dough back or replace them or resupply them. So there is means to limit that. Most importantly, in those limitation of liability clauses, particularly from an entrepreneur's point of view, you just don't want to be liable for consequential loss that can flow from anything. And that's one of the big things, and you'll see a lot of those clauses have got that, not liable for direct, indirect, consequential loss, economic loss, etc. So it's probably a long-winded answer to your question, Steve, is it does help, but geez, you're probably going to settle most disputes anyway, because the only ones that win going to court are blokes like me.
The boys always win, that's all good. I just had a thought, actually, it wasn't in the notes, around, we've done some deals, and we had 3 deals in December. We've done 4 deals since December. And with when I say deals, it's an investment deal. With that always comes a subscription agreement, for example. And there's a lot of warranties inside a subscription agreement. I'm just casting my mind through that, we made a lot of assumptions in crafting those warranties. A lot of I think would be destroyed and left in tears at this point in time. So, have you seen anything or have you heard of anything in that space around funding downstream effects of COVID and the funding around subscriptions and potentially warranties made?
Not yet, because I think people are still holding their breath, trying to figure out what's going on.
It's not moving along, has it?
It seems, what are we, about 3 or 4 days after significant law changes that will probably come to, and people are still grappling with that and what it means in a practical sense. I think a lot of people are just trying to figure out what to do and how to get through this. And I know certainly from the legal point of view, most of our focus has been on the employment stuff.
So over the weekend, Scott Morrison announced a massive raft of changes to the regulatory environment with respect to insolvency and other bits and pieces. This is following on from a good few years ago when Malcolm Turnbull and White Roy announced the NISA. So they had a substantial alterations to the corporations framework with respect to safe harbour, ipso facto, and a few other bits and pieces. I'm not really going to cover that because on the weekends the Prime Minister came out and announced a 6-month holiday from insolvency requirements. I might get Ashley to explain a bit more because I'm sure I've done that no service at all.
Actually, a really good description of where we're at. It's basically giving businesses 6 months to try and see where they go and give them protection to keep businesses running. Because what the law basically does is instead of 21 days to comply with a statutory demand or a bankruptcy notice, we're out to 6 months. So
is that 6 months plus 21 days, or
yeah,
it is okay.
No, sorry, it is just 6 months.
Yeah, okay, yeah.
And look, that's a long time.
Yeah,
that's a long time. So there's probably a disincentive to be issuing statutory demands because what are you going to do? Sit and wait for 6 months. There's also the holiday, if we can call it that, on liability for insolvent trading for directors. So I think that's designed to keep directors bums on seats, keep that corporate knowledge so people
parachute out,
can trade through. But equally, is it going to create some mischief with opportunistic people? That's one thing that the regulators are going to have to be keep their eye on. And there was a carve out in Frydenberg's information sheet that came out about fraud and gross neglect and all of that, and that's totally understandable.
Yeah, I understand that also.
So I think where we're at with the changes in the law is it's going to give businesses time. They're not going to be under pressure from creditors to pay down debts. Now that's going to have a range of practical effects for people.
How does that flow on? So there's the date, whenever it becomes royal assented or however they enact that, I'm not too sure what's going to happen. So does that absolve the past, or can you go forward into this new realm as well? Because surely you have to recontract with other people.
You do.
And the concept of insolvency is you can't take on new liabilities.
We can't incur a new debt.
New debt, sorry.
While you're insolvent.
While you're insolvent.
Or which could lead you to become insolvent.
So how does that work? Oh, good hope. No answers. It's a new world.
Well, I think what it means in a practical sense is a director is going to be allowed to make decisions to incur debts when the company is technically insolvent.
Well, there's no liability in director now, isn't it? So
that's right.
Yeah, right.
So I think that's where there is...
How is incurring a debt whilst you're insolvent not gross negligence?
Well, that's another issue, isn't it? Is it breaching 180, 181, 182 of the Corps Act? And they haven't gone that far.
Yeah.
Maybe they will, maybe they won't. There is, of course, I'll call it the excusal provisions in the 1370, 1380 of the Corps Act that allows the director to be excused. And you would have thought a court might be willing to look at that in the current context.
So how can, that's good background, and not knowing fully how it's probably going to be implemented, but we've got some framework there. How could companies take advantage of that, I suppose? So we look at, right behind us here is our portfolio. There's a certain amount of companies in there trying to understand their options going forward. Some have just seen their revenue fall from tens of thousands a day to zero. That's almost makes it instantly insolvent. So there's coverage, which is nice now, so they can actually take time to get their affairs in order, for want of a better term. Have you seen, is there a general strategy that you're recommending that you've seen that you could even think of, that they can, maybe a framework for thought, how they could take that process forward?
I think common sense is probably the starting point for this, which is if revenue's down, you've got to control your outgoings. So you've got to do your own cash flow analysis just to see what are essential to keep your businesses going. And we've already seen in Australia, staff stand down, so our employment costs. What were they historically at 30%? I think employment costs are now on average about 40% of a business, certainly in professional services. So people being stood down, made redundant, so we're controlling our outgoings. Renegotiating with landlords, trying to get that down, because landlords, if there's no revenue, they're not going to get anything, so they're better off taking something. Money's never been cheaper in Australia. And I know banks are trying to say, come and borrow money. So, banks are looking to do deals. And, interest rates with a 2 in the front, I can't remember that ever.
No.
So it's probably an opportunity to consolidate and renegotiate your debt while banks are looking to assist. And keep in mind, banks are giving people holidays at the moment too with loan repayments. Yeah. And,
so strategies to go to a bank. So let's assume you've got a business and you've got, let's say, $5 million worth of debt. I don't know what it might be. Not so much for this space up here with this crowd, but this video will go a lot wider. So how do you go to a bank and say, right, we want to do something here that we can offer you $2 million, for example, for your debt, or whatever it might be? What should you go in with an Ashley Tiplady or a turnaround person, or what is the best way to approach that conversation with the bank?
Well, it's going to come down to what you're going to give the bank as security, because even though banks are going to be looking to do business, they're not going to do stupid business. So they're going to have a look at your cash flows, your cash flow projections. So you're going to have to still present a business case to get your borrowings. Yeah. And is there real property that can stand up as security, something like that? Are directors going to be willing to put up personal assets as security for new loans? It's a bit of an unknown, but certainly you're going to have to justify any loan.
So you're saying that the banks aren't necessarily they're not trying to save the furniture, they're still a control. They're not going to be sort of taking silly deals at this point in time.
No. I think we got rid of that about 10 years ago.
Yeah, the GFC compared that one, didn't it? Some silly deals.
So look, certainly debt consolidation and renegotiation, but I think really importantly is businesses examining their own trading terms. Because cash is going to be king, getting paid is going to be important. Are we going back to a COD type arrangement? Maybe we are.
So getting a world where directors can escape insolvency issues, so you can incur debt, not pay your supplier essentially. You're going to want to change that. That's what you're talking about, right? Change the trading terms. So what's in it? You can reorganise your own affairs. Someone else is reorganising their affairs against you at the same time. So you've got to think about this from both sides of the parapet. That's what you're saying.
So if I'm trading and I'm supplying goods and I'm giving credit, I'm probably looking at maximum 7-day payment terms. I'm probably looking at what security can I get over my supplier to pay me. So it's really renegotiating terms of trade. I think it's going to be really important. Because as we all know, once your debtors get out to 90 or 120 days, they're very difficult to recover. Maybe that's now changed to 7 to 14 days. So I'm certainly saying to a lot of my clients, it's almost COD unless you really trust them or there's some form of security, because you've got to get paid.
So that's it, isn't it? So being able to manage that cash in this environment here. So with standing advice from that to me is, like I said, don't think about months with respect to your age, but think about terms of weeks with respect to your age.
Well, it's even more important now, Steve, because with the relaxation and holiday on stat demands, they're no longer the threat that they were.
Exactly right.
And we all know going to court is a 12 or 18 month process to get a judgment. So the threat of litigation and debt recovery has just evaporated, which is good and bad.
It's good and bad, no?
But we've got to be behaving ourselves as individuals, and maybe that is going to be a COD type arrangement for goods coming in.
So with respect to, Scott Morris announced the weekend of the 6-month holiday, there is another shoe to drop, we think, out there, which is probably the some form of holiday relief at the state level with respect to real estate tenancies.
Well, it's just really important, because at the moment the federal government's given an opportunity, given time for businesses to try and keep the doors open and keep operating, but it's no good if they don't have premises to operate from. And that's a state government regime.
There's also, it's not just the lease, but there's also the potential to call rental guarantees.
Bank guarantees, yeah.
So it's a multi, and bank guarantees can be a quarter to a year's worth of rent revenue, right, essentially. So rent expense.
And look, I understand state governments are looking at that at the moment. Are they going to extend the time frame for terminating leases? Are they going to restrain landlords from accessing bank guarantees or security bonds? I think they've got to.
Can they? I suppose they can, but I mean
they can do whatever they like.
Can't they? It's up to lawyers to fight it out then. And so, getting back to the force majeure then and the other frustrations and impossibilities. So, on a lease, you said there's typically none of those elements. I've looked back through 2 of my leases and I couldn't find an FM clause in those.
No, they're pretty rare.
So, are you aware of any good levers that entrepreneurs can pull inside those leases in order to? aside from that, what you should do is have the polite conversation with your stakeholder, your landlord to start with. Failing that, wherever you leave as it can be towed.
Well, I think with how quickly things are evolving these days, the frustration of a lease is going to be a real possibility, because if a tenant has contracted to occupy premises to be able to conduct a business to earn revenue, if there's a government directive to shut that business in total, as opposed to the restaurants and cafes at the moment.
What about the 4 square metre rule? So let's say you can't do the 4 square metre rule. Or
just
whatever.
because it's more difficult, more expensive, less profitable, I don't think that's going to amount to a frustrating event.
Yeah, fair enough.
So, that's what you're looking at, is with these new directives and illegal activity, is that frustrating an agreement that allows it to be terminated?
You almost report a case of corona inside your lease just to get the out clause, wouldn't you? Don't recommend you do that. But
that's where we're heading. It's such an evolving world, and so quickly, you've just got to be on top of all of this.
Yeah.
And let's face it, if businesses shut down, there is no revenue, there is no way to pay landlords. If you're taking advice to reduce your outgoings, and we accept that this is a long-term position that we're in, and by that I mean 3-6 months, possibly longer, why would you be sitting in a lease?
Yeah. Co-working spaces are looking pretty good at this point in time, I suppose. Aside from the commingling and the public health effects of that.
And what it does is it creates all sorts of social issues for us, Steve, and maybe someone upstairs is telling the world to wake up and have a look at itself. Do we need to look after each other better? And do we not need to be driven so much by the dollar and commerciality, materialism? We might crack a beer and talk about that later on. Actually, that's a different podcast, isn't it, that one? So we've covered off on a lot of the details there. Initially, we planned talking a lot about safe harbour and bits and pieces, but that changed over the weekend, and so that old regime has been superseded by the 6 months. Is that I think in a practical sense, yes, because now businesses have got that 6-month opportunity. There is no insolvent trading for directors, so you should probably still be vigilant of safe harbour and know what it means. And similarly, I think businesses that were close to the wall.
So if I could just quickly describe what safe harbour is, and you can probably give the better description, but essentially prior to Sunday, that you could actually, if directors were under the impression or the fear they may be insolvent, they could actually enact safe harbour regulations, and that they could seek external advice in order to actually assist them through a process, providing that their statutory obligations to the tax office, which I believe are reporting obligations, get your legal advice on that one, and also obligations to employees were met. And you could actually have a managed form of assisting the company. You may be insolvent, and there's some defences for that. Is that
That's a good summary, and it means that the directors aren't personally liable.
That's it. Yeah.
That's really the crux of your safe harbour, is allowing directors to make hard decisions, and it stops people parachuting and jumping on boards.
Yeah.
So that was the reason for it.
And I think if you've got the time and the house isn't on fire type situation in your business, looking at the guidelines around safe harbour operates is not bad. You bring in an external person, typically turnaround person, might have your legal background to assist you. Because you've probably never been in this situation before, and they do this for a living. So I recommend turnaround people. I imagine Mills Oakley's got a turnaround division. We've used other firms in the past. There's a turnaround management association, which I'm sure can line you up. The TMA Australia can line you up with some people there as well. So look for that expertise and advice.
And look, one thing I would say to business owners is, if you're sailing close to the wind and you're almost cooked before this, think about your restructuring now, because the Corporations Act, through a voluntary administration, a deed of company arrangement, does offer opportunities to restructure. In a practical sense, now, if you're going to get a deed of company arrangement through, maybe you're going to get it through for less cents in the dollar now than you would otherwise, because people are going to want some money. So there might be, some upside. So if you're sailing close to the wind, I wouldn't wait for restructuring. I'd go and have a look at it, because commercially you might be able to get out for less now than you would in 12 months' time.
With the way you spoke before about doing practical stuff and common sense things and managing your costs, because your revenues disappear, so and the lever you got left is that cost lever. In our portfolio, I love the tech startup space because the feedstock is people, smart, young, typically young. We're very well educated, well trained people. Unfortunately, when it comes to a downturn, you've only got one lever to pull there as well. That's typically people. With all the stuff that's announced, has there been anything is there any commentary with respect to unfair dismissal, stand down or redundancy? Is anything being done with that, or are there?
There's obviously a lot being done now about stand downs and the inability to, or because of supply reasons, there's just no available work to employees. What I've seen a lot, and hats off to a lot of people, is employers and employees are renegotiating to keep people round for a proportion of their usual salary, just so there's some money coming in.
So the same way you negotiate with a creditor, you can also negotiate with your employee base and say, look, revenue's halved, therefore something has to change. Let's talk about this in a mature way and get an outcome for everybody.
And very few times, and imagine there's been a lot of this going on over the last sort of 72 hours particularly, there's arrangements being done where people might be say, I'll take $500 a week instead of $1,000 a week because it's money coming in. I'm not forced out into the dole queues and all that sort of thing. So people are being mature, and I think that is the way to go. That if there's not work, let's spread it round, halve people's salary, put people on part-time work and renegotiate. Now, how long's that for? We just don't know. But that's probably the mature way to do it, is it keeps you good people employed, keeps money in the door. And from a social point of view, it means the government's not having to dig into its coffers. Because let's face it, we're billions upon billions of dollars into this, and maybe we haven't scratched the surface.
Well, I actually heard the $189 billion package is now being called, some stimulus package is now called the first aid package. So I can't remember the exact term, but they intimated there's a lot more to come, and I thought, oh God, we weren't exactly debt-free before this, right?
Well, how are we funding all this? It's a generational issue, but as you say, that's probably an issue for another day and another podcast.
I've got a bottle of white as well. Well, with that, I might wrap it up there, unless there's anything final that we probably haven't covered.
Look, I just encourage people to be proactive about this and deal with it. Don't stick your head in the sand, because if you get on the front foot now and you're being compassionate, and I think don't be opportunistic, be compassionate, do the right thing by society. We can all get through this. But just don't stick your head in the sand.
It's a good thing. For me, when I first heard 6 months, I thought, wow, that's great. And I thought, that 6 months will probably fly. So don't think you've got a lot of time here. To Ashley's point before, use as an opportunity now. Don't wait for 12 months to start maybe pulling some of these levers, but understand what you can do now. Once again, I want to thank Ash Tiplady from Mills Oakley here in Brisbane. I also just let you know that this video is going to be edited using Clipchamp, the best video editor around, one of our portfolio as well. So I'll put a plug in for that. We'll get this up online, and look, the one thing I'll say out there, if your business is struggling, this is not good, but you're not Robinson Crusoe. We're all doing it pretty tough. Have a talk. The sun will come up tomorrow, and we'll try our best to get you some more content.